Wanted to say that my topic, construction contracts, is not a self-help topic. It's something to give you a framework to look at these construction projects, mainly major projects, and to give you some idea of the different steps that are involved. I wanted to know, though, I'm really impressed by the turnout today with these four very diverse topics. Well, who of you are really drawn to come here today to hear about contracts? Okay, that's pretty good. When I started practicing in this field a long time ago, I was given all of the contracts to work on, and it wasn't like I won a lottery or anything. It was sort of the opposite, because nobody really wanted to do them, I think. And so I ended up doing them for the firm, and I've come to enjoy them because I think it's when you're starting a construction contract, a project, you're really starting with a clean slate, unlike a lot of other things in the community association world. You're starting a project from the ground up, and you have the opportunity to get a really good result if you do certain things, which I'll be talking about. But you also have a risk that if the project goes bad, it could cause delays, or it could cause you to spend a lot more money than you would have otherwise. So my presentation is on this page, which I'm sure everybody is at. It's 7 pages, and I've numbered them so you can kind of follow along. And I'm not going to follow the outline exactly, because I only have 17 more minutes to talk. And so I'm going to kind of give a different framework to this, so that you can kind of understand the big picture, and then you can read the details about it later. But I think everybody's heard of the 5 stages of grief. Okay, well, I have the 5 stages of contract preparation and execution of construction projects. So, and because Milton named this do's and don'ts of construction contracts, I'll try to put this in the context of do's and don'ts. So, just an overview. First, you need to do your homework, which is basically to lay a foundation for your project. 2, you need to get bids, and you need to vet your contractors. 3, this is a don't sign the contractor's contract. And I would say you should contact your association attorney before signing any kind of contract that's going to be of major consequence. 4, and this is a hard one, but don't assume that the contractor is going to do the work properly. 5, do plan for failure, because that is definitely a possibility, and you can control the risk substantially if you have certain things in place. So the first thing is do your homework. And the first topic that I always talk to boards about is fiduciary duties. Has everyone heard that term, fiduciary duty? Well, what it means is that, as a practical matter, it means that as directors of volunteers on a small, relatively small condominium project perhaps, you actually have a higher duty than, say, the general manager of the Sheraton or the Marriott or the Ritz-Carlton. That is really a daunting thing. And so you're given all of these duties and responsibilities. Among them are the duty of obedience, diligence, loyalty, and good faith. And along with that comes the possibility of personal liability. Although there are a lot of things in place to protect boards, including insurance and indemnity provisions in contracts, there is a personal responsibility that everybody takes when they serve on the board. And so it's really important to understand that. If there aren't here, I put on pages 1 and 2 of my materials some discussion about fiduciary duties, and there are publications that are on the Real Estate Commission's website, and I've given some links in my materials to those pages, and they're very good materials talking about what the duties of directors and officers are. The second thing about doing your homework is that when you're about to embark on a renovation project, there's certain things that you as board members need to study. And basically, the condominium projects are sort of simple in that there are 3 categories of things. There are things that fall within the category of the apartments. There are things that are limited common elements, which are basically common elements that are reserved for 1 or more apartments, and then there are common elements. The problem is that trying to figure out whether something is, for example, a common element or a limited common element or part of the apartment can be very, very challenging. There's a case that I mentioned on page 3 of my memo, or my outline, Harrison versus Casa de Amdico, which was a case in Kona. It was a case to which the court applied 514A, not 514B, so they applied the predecessor Condominium Property Act, but it is a good reminder of the problems that can happen if you don't go through this analysis of figuring out what a component is. For example, lanai railing. Is that, if you're going to replace the lanai railing, is that part of the apartment, or is it a common element, or is it a limited common element? And I guess in the wisdom of the people who created condominiums originally, they left a lot of things up to individual developers to create documents to spell out these things, and some of them do a better job than others. And the problem is that it's kind of like a custom suit or something like that. Every document is different. So there are thousands of condominium associations, I think, in Hawaii. Every document is different in a little way, and there may be some similarities, but you can come to a different conclusion based on different documents. So Casa de Amdico, for example, they said the elevator was a limited common element, pertinent to some of the units, but not all of them. And they had a commercial unit or 2, and so the commercial units were not supposed to be charged for the work on the elevator. And they said there are questions about whether the drains are limited common elements, and the lanai railings are limited common elements. Or the hallways are limited common elements. So that can have a major effect on how you're going to charge for it, and even whether it's something that the association should be doing. So you need to go through that analysis early on, because you could save yourself a lot of headaches, and if you end up like the Casa de Amdico Association, years of arbitration or litigation. If you take a look at these issues, you can amend your documents if necessary to get everything squared away at the outset, and just start your project on the right trajectory. Other issues, you may need to get owner approval for alterations. If you're going to borrow funds, these days, as you know, renovation costs are extremely expensive, especially when you're talking about railings, windows, doors, pipe replacements. So talk to your attorney about the requirements to borrow funds. And that brings me to the suggestion that you really need to assemble a team of people. On a large renovation project, you may need a project manager, you may need design professionals, and definitely on any project, you need to consult with your insurance agent, and Josh will be talking about that. My advice always with contracts, if you expect to get something from the contractor, you need to put it in writing. Otherwise, don't bet on getting it. And I talk about that in section J on page 4 of my materials. So the deliverables from this doing your homework stage, you would get plans and specifications, you possibly get an amendment to your governing documents, and authority to borrow funds. So the second stage is do get bids and vet contractors. The DCCA has really excellent resources. You can check business registration, you can check licensing, categories of licenses, and you can check for RICO complaints, that's Regulated Industries Complaints Office. And so you can find out a lot of information. I'm surprised how often I get contracts to prepare, and when I look up the contractor, they don't have a license, or the license is the wrong kind of license. That's things that you can do at the board level. And I would caution boards not to rely on the names of contractors, the reputations, because sometimes you may get, the information that this contractor worked on the Marriott or some huge project here, and they're all, the client was happy with the work, and so people kind of let their guard down. But that's not an indication of what's actually going to happen on your project, because I think the most important factor in the work you get is who are the people actually on the ground, the foreman for the project, who's performing the work. So focus on the team that you're building and who's actually doing the work. The third stage, don't sign the contractor's contract. I've never seen a contractor's contract that was even-handed. If they're at all intelligent about contracts, they'll have an attorney draft it, and it'll be filled with provisions that protect the contractor. On large projects, large meaning, say over say $100,000, going into the millions. Most contractors are comfortable working with AIA contracts. Is everyone familiar with AIA? No, American Institute of Architects. So the AIA publishes form contracts, and they go back to the early 1900s, and they're modified every 10 years. And these contracts are probably the most even-handed industry contracts that you can find, but they do need to be modified. And even the AIA says that these documents have provisions in there that are just put in there so that you'll consider them. But the documents are very long. But because they've been around for so long, most contractors are familiar with them, so it doesn't require, reading it line by line. But some of the common problems that I find in contracts, limited liability provisions, they may say that we're not responsible for more than the amount of the contract, which could be a huge problem. And you almost think that that kind of provision wouldn't be enforceable, but they are enforceable. And indemnification provisions, the association should always be the party indemnified, not the party who's going to have to indemnify the contractor. Limited warranties and disclaimers. My recommendation is that if the contract is going to be of any consequence to the either financially or potentially causing damages to the project. If the work doesn't go well, have an attorney review it, and if the finances are an issue, talk to the attorney about sort of alternate ways of reviewing the contract. But the board really needs to know whether whether they're really buying into a major liability. 4, don't assume that the contractor will perform the contract. I know that's really tempting, especially for people who are busy or volunteers. I fall into this category myself. When I hire a contractor, I just want to sort of step away and let the contractor do its thing. But that's really not a prudent thing to do, especially when you have a fiduciary duty. The more that you can be hands-on on the project, the better. But what you want to do is to find qualified people to help you with that. That may involve design professionals, construction managers, or even maybe somebody on the board who has special expertise in a certain thing. Unfortunately, that often doesn't pan out to be the best solution because people are volunteers and may not have the time to do all of the inspections necessary. But there are procedures, and I discuss it in my materials, what they are to protect yourself. You definitely want to have a punch list so that before you make the full amount of your payment, before the contractor leaves the project, you do a thorough inspection and get everything fixed, because as you know, once the contractor leaves the project, it's really hard to get the contractor to come back. The last stage, just a few things to plan for failure. You pray for success, but you plan for failure. And insurance, which you'll hear more about. Warranties, I think warranties are the most overlooked parts of contracts. And the AIA documents have really good broad warranties, but if you don't pay attention to the warranties, you may get something less than a year. Frankly, I think if you're spending millions of dollars for work, you should get more than a year's contract. I mean, if you buy a car, nowadays you get, I think, 5 years or 4 years. But you should get a decent contract warranty. Bonds, on pages 6 and 7, I have a discussion about what payment and performance bonds are. And those are definitely something you should expect to get on a significant size contract. So those are the 5 do's and don'ts. Do your homework, do get bids and vet your contractors. Don't sign the contractor's agreement. Can we all pledge that? Don't assume the contractor is going to perform the contract properly, and do plan for failure. Thank you.